Will you be able to receive a green card if you have overstayed your visa? Hi, my name is Audra Doyle, and I'm the owner and attorney of Doyle Law here in Atlanta, Georgia. And if you feel like this video is helpful for you today, don't forget to subscribe to my channel and also click the bell so that you're going to get updates when I upload new videos. This is a very complicated question, and you need to understand a few points of immigration law before you can determine if you are able to receive a green card even though you have overstayed your visa. So number one, who has overstayed? Well, the answer to that question can be found on your I-94. So if you go to cbp.gov, you type in your passport information, it should show you information about your most recent entry to the United States. And on that I-94, there will be an expiration date. If you are past the expiration date, then you will know, yes, I have overstayed my visa. Now, exceptions to the rule, because in this area there's lots of exceptions. Number one is if it says D/S, which means duration of status. Another exception could be that although the CBP form says expired, you have filed an extension of stay to extend your time in the United States, and therefore you may not have overstayed. All right, the second thing to look at is whether you are now unlawfully present in the United States. And I would go back and look at that I-94 document. I would look and see if the client has filed an extension of stay and what's going on with their current non-immigrant status. So let's say, yes, you have overstayed. What do you do next? Well, there is a group of people, a category called immediate relatives, who will still be able to get a green card even if they are unlawfully present. They've overstayed their visa, and Congress set it up this way because Congress wanted immediate relatives to be able to stay with their U.S. citizen family members. So an immediate relative is a spouse of a U.S. citizen, a parent of a U.S. citizen, or a child under 21 of a U.S. citizen. Those are the immediate relatives. And they will not need to do anything special about their case. Even though they have overstayed their visas, they are out of status right now, they may be accruing unlawful presence, they should be able to still receive a green card as long as everything else looks good on their application. We haven't even talked about the other ways that people can get in trouble with filing their green card applications, but I have some other videos about that here. Now, the next thing to think about is if you are not an immediate relative, will you be able to receive that green card if you're currently accruing unlawful presence, you've overstayed your visa? The answer is maybe. For employment-based cases, I think it's going to be very difficult to be able to file for a green card within the United States. You may have to go out of the United States and consular process your application. Another group of people, they may have family members in the U.S., but they're not immediate relatives. They may be eligible for a waiver. And the waiver says that my U.S. citizen relative is going to suffer extreme and unusual hardship if I have to go home to my home country. If the waiver is approved, those people may also be able to go to the embassy abroad, show the waiver, show the family relationship, and be able to come back into the United States with an immigrant visa, which will lead to a green card. But the takeaway from this video is if you are not an immediate relative, it is going to take additional work, or it may not be possible for you to receive a green card if you have fallen out of status. The last 2 points that I want to make, number one, if you are accruing unlawful presence, there is a point in time legally when we say, yes, at this time you're accruing unlawful presence. If you're accruing 180 days or more of unlawful presence, then you are subject to a bar. You can't come back to the U.S. for 3 years if you leave. If you have accrued more than 1 year of unlawful presence, you are subject to the 10-year bar, and you can't come back to the U.S. until 10 years have passed. Once again, we would then look and see if any waivers are available. The last thing that I want you to be sure of is that these are legal issues. These are things that you need to talk with an immigration lawyer about, because there could be a way to show you're not accruing unlawful presence. What if you have the DS? What does that mean? What if you're an immediate relative? What if you're eligible for a waiver? So I think it's a good idea, if you're in this situation of being out of status and you may be eligible for a green card, do not apply on your own. I strongly recommend that you contact a qualified immigration attorney to go over your options with you. As always, if you have any questions, please let us know.